So good morning, everyone. I'm Alex Nanoff. I'll be moderating the press conference this morning for the launch of the Fresh Start Coalition. Present, we have representatives from the Canadian Civil Liberties Association, BLAC, the Community Legal, the Canadian Civil Liberties Association, the Indigenous Bar Association, the Canadian Association of Elizabeth Fry Societies, the John Howard Society, as well as BLAC. Bonjour à toutes et à tous. Ici présents aujourd'hui, nous avons des représentants de l'Association canadienne des libertés civiles, de BLAC, de l'Association du barreau autochtone, de la collectivité d'association Elizabeth Fry du Canada, de la société John Howard, ainsi que de l'organisme BLAC, pour participer à une conférence de presse pour le lancement de la coalition Nouveau Départ. Those present will offer a brief statement, followed by a question and answer period from members of the media. Nous commencerons par de brèves déclarations par les membres présents, suivies d'une période de questions-réponses des membres des médias. Please ensure that your mic is muted, and I will now pass off the floor to Abby Dashman. Abby.
Thanks very much. I'm the director of the Criminal Justice Program with the Canadian Civil Liberties Association, and it's my pleasure to be here this morning to announce the launch of the Fresh Start Coalition, a group of nearly 70 civil society organizations that are uniting to urge the federal government to revamp the way Canada deals with old criminal records. Canadian law currently allows most people who successfully complete their sentence to apply for a record suspension, lifting the burden of an old criminal record. But the system as it stands now is broken. It is slow, exceedingly difficult to navigate, and expensive. For many, the promise of a record suspension is completely out of reach. And this means that jobs, education, housing, and with it, the stability needed to rebuild lives is frequently out of reach as well. It's a situation that disproportionately impacts our most marginalized communities, deepens systemic inequality, jeopardizes community safety, and places needless barriers in front of job seekers. The evidence is clear that criminal record checks for the purposes of basic employment, housing, and volunteering are not good screening tools. Simply put, we do not make communities safer by keeping people in poverty, preventing them from accessing jobs, stable housing, or meaningful community connection. This is an issue that impacts hundreds of thousands of people across the country. As many as 1 in 9 Canadians have a criminal record of conviction, and many more have non-conviction records that may be revealed on certain types of police checks. Those in communities that are disproportionately policed and criminalized, including Black people and members of other racialized communities, Indigenous persons, those with histories of homelessness, mental health challenges and addictions, along with many others who are marginalized, those communities bear the brunt of these harms. The breadth of our coalition, which includes organizations working on access to housing, violence against women, mental and physical health issues, racial justice, Indigenous reconciliation, and more, is a direct reflection of this reality. Today, we are calling on the Canadian government to finally deliver real reform to the record suspension system by doing away with the unnecessary and complicated application process. Record suspensions should be automatic for those who successfully completed their sentence and lived in the community for years. This simple change would dramatically increase individuals' chances of accessing employment and stable housing, transforming people's lives, increasing community safety, and curbing systemic discrimination. Thank you. Alex, you're muted.
It's bound to happen at least once. We're now going to pass it off to Moya Teklu, Executive Director of the BLAC Legal Action Center. Nous allons maintenant adresser la parole à Moya Teklu, Directrice de la BLAC Legal Action Center. Moya.
Thank you, Alex. The BLAC Legal Action Center is proud to be working with the Canadian Civil Liberties Association, the John Howard Society, and over 60 other community organizations as part of the Fresh Start Coalition. This is a racial justice issue. We know that Black people face discrimination on the basis of race in education, employment, health, and housing. We know that these social determinants of justice are the very things that keep people out of the criminal justice system. We know that racist policing and biased decision-making at every single stage of the criminal justice system, from who gets charged, arrested, detained, held in pretrial detention, sentenced, paroled, etc., means that Black people, despite not necessarily committing more crime, are more likely to be caught in the criminal justice system. And finally, we know that having a criminal record makes it even harder to obtain education, employment, and housing. This essentially means that not only are Black people more likely to be caught up in the system, they're more likely to be trapped in it. The current regime is expensive and onerous. It should be automatic and barrier-free. We are calling on the federal government to prioritize public safety over law and order soundbites, to take concrete action to address the devastating effects of anti-Black racism in the criminal justice system, to break the cycle of criminalization, and to give people who have done their time an opportunity at a fresh start. Thank you.
Thank you very much. We'll now go to Alain Bartleman from the Indigenous Bar Association. Nous allons maintenant passer à Alain Bartleman de l'Association du barreau autochtone. Alain.
Minogazeb, everyone. Good morning. The stigma of a criminal record jeopardizes the future of Indigenous persons who hope to pursue gainful employment, housing, and education, and who wish to secure a place within their respective communities, whether on or off reserve, as active participants. Indigenous peoples suffer particularly from the residual burdens of criminal records as a result of their disproportionate representation within Canada's criminal justice system. Implementing a regime by which record suspensions will be automatic, as envisaged by the Fresh Start Coalition, will help to alleviate these burdens and mark an important path towards reconciliation. Miigwech.
Thank you, Alan. Next, we'll hear from Emily Coyle from the Canadian Association of Elizabeth Fry Societies. Nous allons maintenant entendre de Emily Coyle de l'Association canadienne des sociétés Elizabeth Fry.
Thank you, and good morning, everyone. As you all know, the Canadian Association of Elizabeth Fry Societies is a national nonprofit dedicated to addressing the human rights issues and advancing the human rights of criminalized women, trans, non-binary, and two-spirit people. And it is for this reason, and in collaboration with our 24 local Elizabeth Fry societies across the country, many of whom have had to offer services for record suspensions for many years now, that we are calling on and calling in the Canadian government to work with us to implement with the rest of the members of this wonderful coalition a spent regime for records. And we do this because we have people who are caught up, as my colleagues have already mentioned, in a system that is unfair and unfortunately expensive and burdensome. People who, like Tina Riley, who has been in the news in Halifax quite often, who many years ago was living in a cycle of poverty like many people that we serve, and spent some time in prison for poverty-related theft charges. And it wasn't until many years later that she learned that she still had a record and that she still owed money on that record. And because of that, the time that she needed to start the process of her record suspension didn't begin until she had paid that fine many years later. And so for her, her life has been impacted entirely by this onerous system. It is complicated, it is cumbersome, and so we see across the country with the other members of this coalition a strong desire to see a new system implemented that will help us achieve our goals of public safety. The current regime does not do that. And so I think that the sheer numbers of the people who are in our coalition really indicate and should indicate a strong desire to all of you, that there is a strong desire to see this regime changed. Thank you very much.
Thank you, Emily. Merci. Nous allons maintenant passer la parole à Catherine Latimer de la Société John Howard. We're now going to pass it off to Catherine Latimer of the John Howard Society. She's the executive director of the John Howard Society.
Thank you very much. Very pleased to be a member of this coalition. I think the time is now to really press hard to see some long sought changes in the Criminal Records Act. We know the way the system operates now is enormously unfair, particularly to those who are marginalized or impoverished. They are denied a remedy that would otherwise be available to them simply because they can't afford the application fee. The time is right to press hard with all of the great members of this coalition to try and effect some very significant changes. We ask the federal government to take a serious look at making the suspension or the closure of the record automatic once the person has completed their sentence and the crime-free period in the community. We know this works. It has worked successfully in the youth justice system, and there's no reason not to apply those principles to the adult system in order to have a much more inclusive society that benefits from the contributions that everyone wants to make. Thank you very much.
Thank you. Next up, and to conclude, we have Talia Shumali of the Canadian Civil Liberties Association, who will offer us a few words in French. Nous avons maintenant Talia Shumali de l'Association canadienne des libertés civiles, qui nous offrira quelques remarques en français.
Mesdames et messieurs, bonjour. Nous sommes ici aujourd'hui pour annoncer le lancement de la coalition Nouveau Départ, qui comprend environ 70 organisations civiles réunies dans le but d'exhorter le gouvernement fédéral à réformer la façon dont le Canada traite les antécédents judiciaires. Actuellement, le droit permet aux personnes reconnues coupables d'un crime de faire une demande de suspension de leur quai judiciaire une fois leur peine purgée, de sorte à alléger le fardeau de leurs antécédents criminels. Mais ce système de suspension est défaillant. Il est lent, extrêmement difficile à naviguer et coûteux. Pour beaucoup, l'idée de voir leur casier judiciaire suspendu n'est même pas envisageable. Autrement dit, la possibilité d'obtenir un emploi, une éducation, un logement et la stabilité requise pour reconstruire leur vie est tout aussi compromise. C'est une situation qui affecte de manière disproportionnée les groupes les plus marginalisés de la société, creuse le fossé de l'inégalité systémique, met en péril la sécurité des collectivités et impose des obstacles inutiles à demandeurs d'emploi. Les faits montrent que la vérification du casier judiciaire en vue de l'attribution d'un emploi rémunéré, d'un logement ou d'un recrutement comme bénévole n'est pas le meilleur outil de sélection qui soit. En bref, nous ne rendons pas nos collectivités plus sécuritaires en gardant les gens dans la pauvreté, en les empêchant d'accéder à un emploi, un logement stable ou de faire du bénévolat dans leur communauté. C'est un problème qui touche des centaines de milliers de personnes dans l'ensemble du pays. Un Canadien sur 9 a un casier judiciaire avec condamnation et une proportion bien plus grande encore a un casier judiciaire sans condamnation qui peut être divulgué au moment de la vérification de ce casier. Par ailleurs, ce sont les groupes qui font l'objet d'une surveillance policière et d'une criminalisation disproportionnée, les populations noires et les divers groupes racialisés, la population autochtone, les sans-abri, les personnes aux prises avec des problèmes de santé mentale et de dépendance, ainsi que les autres groupes marginalisés qui subissent le plus grand de ces préjudices. L'ampleur de notre coalition, organisme qui travaille pour défendre l'accès au logement, combattre la violence faite aux femmes, faire face aux problèmes de santé mentale et physique, promouvoir la justice raciale et faire avancer la réconciliation avec les Autochtones reflètent ces réalités. Aujourd'hui, nous exhortons le gouvernement canadien à enfin réformer véritablement le système de suspension de casier judiciaire en se débarrassant d'une procédure de demande inutile et compliquée. La suspension du casier devrait être automatique pour les personnes qui ont purgé leur peine et vécu dans la collectivité pendant des années. Cela permettrait d'accroître considérablement leurs chances d'accès à un emploi et à un logement stable, de transformer leur vie tout en augmentant la sécurité de collectivité et en réduisant la discrimination systémique. Merci.
Thank you, merci. We are now going to open the floor to media for any questions. We'll have a question with a follow-up before we allow the next person to ask a question. Nous allons maintenant passer à la période de questions pour les médias. S'il vous plaît, signalez dans la boîte chat si vous désirez poser une question. Nous allons avoir une question avec suivi pour chaque individu qui pose une question. Please make sure you signal in chat if you would like to ask a question. We're going to open up the floor now. First up is Jim Bronskill from the Canadian Press, excuse me. Jim, the floor is yours.
Good morning.
Yep.
I'd like to ask a little bit about how the spent regime would work, in the sense of who would decide whether someone had lived in the community successfully without convictions for long enough in order for this to take effect. Would that not require the same sort of administration or a similar kind of administration as the current regime, where you have people saying, yes, you have met the benchmark, you can now receive, our whatever it would be called, sealing of the record under this new regime? Would it not entail the same kind of bureaucracy or arbiters to decide who passes that test?
Would someone like to jump in on that? Please just.
Catherine, go ahead.
Yep. Catherine, the floor is yours.
Thank you very much. The way it works, Jim, in the youth justice system is that these are records that are held in the RCMP CPIC file, and it is simply a matter of flagging the record and ensuring that there have been no subsequent convictions during that crime-free period after the sentence has been completed. So what it does is it avoids the subjective criteria that can be imposed, which they have now, which is that the applicant has to demonstrate that this is in the interest of their rehabilitation, and that it would not bring the administration of justice into disrepute. Whenever you get subjective criteria like that, it tends to be applied in ways that some of us would find discriminatory against marginalized groups, and where there's preconceived ideas about people's criminality. But the true and objective test is the extent to which they have not been convicted of any subsequent offenses during that period. And that's the hallmark of rehabilitation and successful reintegration. So it can be done really automatically through the RCMP CPIC files.
Quick follow-up, thanks.
Yep, follow-up.
In your materials today, that you would you've hired a consultant or an expert, commissioned one to look at the periods of time that one must wait that would be acceptable for various circumstances. Could you elaborate on that, please?
Abby, do you want to take? Okay.
Sure. Right now we know that the government is interested in bringing the timelines for record suspensions back to 3 and 5 years, which it was for a very, very long time before tough on crime amendments came in during a previous government. So it is something that we are actively looking at. We certainly think that 5 and 10 years, where it's set now, is a significant barrier to people accessing rehabilitation and reintegrating. It keeps people in poverty for far too long. It's not evidence-based. So we will be continuing to study it, but certainly we support the proposed changes that came in just before the election to reduce the wait times.
Apologies, I was muted again. Thank you, Abby. We now have a question from Stéphanie Marin à Le Devoir. Nous avons une question de Stéphanie Marin avec Le Devoir. Stéphanie, la parole est à vous.
Oui, bonjour. Est-ce que vous m'entendez?
Oui, on vous entend.
Fantastic. I think I'll go in English. It might be easier for all the participants to jump in on this one. Because my first question is maybe because it's a language issue, but we'll see. What you're proposing, the automatic spent record system, is that different from the pardon system that exists? When you're saying that the current system is not automatic, are you referring to the pardon system or some other system? I just want to make sure I'm understanding the process here.
I'll just answer quickly. It's the pardon system. So it was previously called a pardon, and then it was changed to record suspension. But those words are used interchangeably. So you're right. It's the same system as pardon.
Okay, so the pardon system was not automatic, and now you would like to move to a system where it is automatic.
That's right. Right now, the burden is entirely on the individual, the applicant, many of whom are extremely marginalized and unable to access the system. And we don't think it's in anyone's interest to place those barriers in front of people.
Perfect. So it was a language issue. Thank you very much. And I was also wondering about the reaction of the federal government to all your efforts. What have they been raising to say that we might want to look towards that, or we're not moving towards that? What are the obstacles? What are they raising as issues?
Certainly, we know that the federal government understands the problems with the system. This has been very clear from committee proceedings, from remarks from elected officials. Just before the election, there was a bill introduced to address some of the barriers that are in the current system. So we know that they are aware of the problem, and we know that they've committed to studying a spent records regime. Frankly, we don't think more study is necessary. This is a regime that's worked in the youth justice system. This is a regime that's in place in other jurisdictions. We know that there is broad support for automatic record suspensions, and they just need to move forward and get it done.
Thank you.
Thank you, Abby. I think that Alain Bartleman of the Indigenous Bar Association would like to add something. Alain Bartleman de l'Association du Barreau Autochtone.
Thanks, Alex. Bonjour, Stéphanie. I'd like to build on what Abby has said and provide a concrete example of a barrier to the pardons process as it currently stands. If you are an individual who lives in a remote community who has been convicted of an offense, you face not only the financial burden of having to go through and pay for the pardons process, but you also face an informational burden in that you might not even know that this process is available to you. And on top of that, you face the issue of delays. We have already the built-in delays, but we also have the reality that for a not insignificant portion of the Indigenous population, they live in areas that are poorly served by telecommunications and postal infrastructure. And so as stands the present system, by having to apply for, wait, potentially send in more documentation and make the case for the pardon system, is really adding additional barriers to their rehabilitation into society. and removing this barrier to further economic integration into their communities. Economic, housing, education, I should say, as well, as the effects of a criminal record spill over into all of these facets of modern life.
Thanks for the precision. It's a great example. Thank you.
Yeah, pas de quoi.
Did anyone else want to jump in from the coalition?
I think one thing that I wasn't able to underscore in my opening remarks was the particular population that we work with, women, trans, non-binary, and two-spirit folks, generally also bear the burden of family responsibilities. And so when there is a record that is hanging over their heads, it can mean for them and their families that they are all going to continue to live in the type of poverty that was the reason that they had initially often came into contact with the criminal justice system initially. And so what this particular regime serves currently is to keep people and their families in consistent cycles of poverty, or at least is one of the ways that continues. And so a spent regime would certainly be a good move towards helping people to start to rebuild their lives in meaningful ways. And you know, this is also something that is supported in the Senate. Senator Kim Pate also has a bill that she has proposed dealing with this spent regime. And so if people are interested to take a look at some of the material that she has also put out there.
Thank you, Emily. Did anyone else have anything to add? Okay. Further questions? If you have a question, please either raise your hand or signal me in the chat. We have another question from Stéphanie Marin, Le Devoir.
Thank you for letting me ask more questions. I was wondering if somebody could elaborate more on the way this has worked well in the youth criminal justice system, just to be able to give some example how it worked and whether there were any issues with the way it was working in that system.
Thank you. Yep. Sorry.
Hi, Stephanie. It's Catherine. Catherine Latimer. I used to be the executive director the Director General of Youth Justice Policy for the federal government when they brought in the Youth Justice Renewal and Youth Justice Act, Youth Criminal Justice Act. And we opted for this automatic closure and a records management system. It was initially resisted pretty strongly, largely, well, change is always difficult. But once it was implemented, it's been operating really well for the last 20 years. There have been no significant problems with it. And it really is thanks to the good officers of the RCMP who manage the CPIC files and do it incredibly well. And it's just a matter of sealing the files. It will take a little bit of effort to ensure that if people want to use criminal records, they have to ensure that they're also recorded in the CPIC file. So there is a bit of an administrative burden, but it's completely manageable, and it works well in the youth justice system. So I think in the Youth Justice Renewal Initiative, there was a real sense that young people, change pretty quickly and radically, and it's important to give them a second chance and not have them burdened by mistakes made early in life. And I would argue that the same thing applies for adults. Many of the offenses that dog people for their entire lives happened when they're in their early 20s and would be understood as being adult crime, but certainly before they're fully cognizant as adults. So what would happen in the youth justice system is that once it was recorded that the record was, the sentence was completed, the period, crime-free period would begin, And once that period had been completed without any further convictions having been registered on the CPIC file, that record would be closed. If there's a subsequent criminal act, that record is available. It doesn't disappear, it just closes and is no longer a burden for civil society in terms of being accessible on employment and housing and a variety of other things that are now extremely prejudicial for people who are trying very hard to rehabilitate and reintegrate and are being, 5, 6, 3 years successful in that under very difficult circumstances. And it's time to relieve them of that burden and give them full protections. Once they get the record suspension or pardon, or the record is closed, they then get protection from discrimination under provincial and federal human rights codes, which they're otherwise denied. So there's open season on being prejudicial and not respecting, not having rights for people who are in that transitional period. And it's really unfair and really needs to end. Youth justice system works like a charm.
Thank you so much.
Yeah.
Thank you, Catherine. Any follow-up question?
I'm good, thank you.
Merci, thank you. The floor is open for any further follow-up questions. Please raise your hand if you'd like to ask any of our participants a question. Veuillez s'il vous plaît signaler si vous voulez poser une question à l'un de nos conférenciers. I'll leave the floor open for another 30 seconds. We have another follow-up question from Jim Bronskill of the Canadian Press. Go ahead, Jim.
Hi, just a quick one. You alluded to it, but have you had any direct discussions with former Minister Blair's office or the new Minister Mendicino in public safety in Ottawa, or officials? Has this got their ear at all at this point? It's a new cabinet, but just looking to see where you are in terms of impressing this idea upon the government, given that they have signaled they want to simply go back to the former record suspension regime of the past.
Yeah, thanks for the question. We have had some conversations with staffers in former Minister Blair's office prior to the election, as well as in the Prime Minister's office. We did send a letter, an email requesting a preliminary meeting with the new minister, Mr. Mendicino. Have not yet heard back, but do very much hope that we will be able to work hand in hand with the government on this. We know that they know about the problems, that they are committed to changing the system, and that they are interested in this as a policy solution. This is a perfect opening for us to meaningfully move forward for really very strong change in this area.
Thank you. Did anyone else want to jump in? Any follow-up on that, Jim? Okay, thank you. Do we have any further questions? Okay, seeing as how there are no further questions, this will conclude our press conference. Thank you all for participating today. En vue de ne plus avoir de questions, nous allons maintenant conclure notre conférence de presse. Merci à tous nos participants et participantes. Bonne journée tout le monde.